Welcome to the Northern Ireland Affairs Select Committee and our session on Operation Kenova. I'd like to welcome Sir Iain Livingstone and Chief Constable Jon Boutcher. Sir Iain, to what extent are you satisfied with the outcomes, achievements and effectiveness of Operation Kenova and its group of cases?
Thank you, Chair. Thanks for the invitation to come here this morning. That's a very complex question, to be candid. Overall, I am satisfied with Kenova's work, the quality of its work, the answers, achievements it's given for victims and families. But against that, I'm also frustrated. In some ways, I think it could have achieved a lot more. You know, that the criminal investigation into the agent Stakeknife, we fought hard to try and give that summary of cases in the final report to make it clear to the public the extent of the inquiries and the work that had been done. So there's an inevitable frustration that those cases were never brought to court, were never tested, if you like, in the public domain for a variety of reasons, and I'm not taking issue with those, but there was a level of frustration in terms of the actual Stakeknife work. But the approach that's been taken and the achievement that's been done in some of the other instances, not least of all Operation Turma, the murder of the 3 police officers at Kennego Embankment in 1982, I think is really significant. You know, we've brought answers to the victims and families that hadn't been heard, hadn't been treated with care and courtesy, had suffered dreadful attacks from terrorists, brutal terrorist attacks, and then, I think, as I said in the final report, aggravated at times by a poor state response to some of that trauma. But the quality of the work and the progress that's been made, I think, is really significant. I think it is a game changer in terms of the approach to Troubles and Troubles investigations. I hope it will inform the work of the Legacy Commission and other matters going forward. But against that, inevitably there are a number of frustrations that perhaps more could have been achieved, but that's life.
And so the family responses to the outcomes and findings of the final report and investigation, how did they feel?
Overall, the feedback has been very, very supportive and positive. They knew, they were aware of the specific prosecution decisions. For example, in terms of those cases where we had submitted case files, those families were then given a bespoke report, again, that has been handed to them, written, documented, explaining the inquiries that were made. And then other families who didn't necessarily receive a bespoke family report because of the circumstances of their own case, again, we've maintained very close relationships, and that continues. That's not something that's going to come to a hard stop. But in general terms, and I am talking in the generality here because we dealt with literally hundreds of families, the families remain very supportive, and I suppose a little bit like us in the Kenova team, and as my reply to you earlier, frustrated with some elements of it, but I think reassured that there was utter commitment to try and get the truth and try and get answers.
Thank you. Chief Constable.
Well, firstly, thank you for inviting us as well to echo Ian's comments about being here and have the opportunity to speak to you. So, outcomes, achievements and effectiveness. So, the outcomes, I think the findings of the Kenova interim report and the final report from Sir Iain just before Christmas are an accumulation of work that probably at the beginning of this came from a referral from the Director of Public Prosecutions in 2016, a result of a number of concerns by previous Directors of Public Prosecutions and the Public Prosecutor at the time, to be where we are now, with the clarity that's been provided to families about what had happened in the Stakeknife investigations, the additional commission of cases that have been the investigations into Operation Turma, the 3 police officers who were murdered in 1982, the Jean Smith-Campbell case, and the series of cases known as the Glenanne series, Operation Denton, because of the success of how we approached it, I think speaks for itself. And the information that those families have been given in family reports by Sir Iain and the team, information that they never had any expectation they'd receive, I think is quite remarkable. Also, both the British government, the Irish government, victims groups have heralded Kenova and the approach, the absolute drive for access to information, the inclusion of victims by listening to them, acknowledging them, and trying to give them the information that they've been asking for many years. As far as an achievement is concerned, I think is something that we probably didn't expect to reach as far as we have. And finally, the effectiveness, if I can link that to efficiency, the costs, the numbers of officers we had, and the approach, I think prove, in contrast to other inquiries, of which, by the way, there's never a criticism from me, because legacy is so difficult for a number of reasons, which both reports set out. I think we achieved far more than we probably ever expected when we were first asked to do this. And I think most of the stakeholders in legacy would agree with that. So overall, I'd have taken where we are now at the beginning with glee. So I think it's been a success. And what a lot of people are talking about now, it's changed the weather for legacy. It's changed the approach. It's brought the government into sharp focus around custom and practice during the Troubles, that without in any way being overcritical, we just need to understand why things happened in the way they did. And I think we've shone a torch on that in a way that hadn't happened before. And the last thing I do need to say, when we started Kenova, we went to see all those who'd done legacy inquiries before. So Lord Stevens, the Judge Corey team, Judge Pomerantz, who was his senior counsel, Judge Smithick, Sir Desmond de Silva, and they really informed and shaped how we were going to do this, because it was through their experiences that we created the model of Kenova. So it's an evolution, and the legacy process that we're probably going to talk to today is an evolution from beyond Kenova, I would hope. What we've got to make sure is that we don't get into the dangerous territory of playing snakes and ladders, where we land on the wrong square and we slip back down again. We've got to make sure that we land the progress and move forward.
And what effect has the UK government's refusal to authorise the confirmation of Stakeknife's identity had on the Kenova objective? And you talked about that, Iain. But the objective to establish a truth and to provide a comprehensive account of Stakeknife's activity in relationship to the security services in particular.
Yeah, I mean, that is a deep frustration that we've expressed numerous times. As we outline in the final report, as John and I articulated when we launched the report, we are not here to undermine the principle of neither confirm nor deny. We recognise its value. We've lived it, breathed it, utilised it, supported it, upheld it for decades, quite literally, in different elements of policing and law enforcement. But when a principle becomes a sort of a rigid dogma that flies in the face of reality, that actually is wholly in contrary to, in our judgment, public interest, I think it undermines that principle and what lies behind it. And where an individual has clearly acted and gone beyond any sense of humanity, far less terms and conditions or conduct and use and language that's used. This is about how an individual, the lack of humanity and the grotesque nature of that criminality. For that individual to continue to take protection, I actually think that undermines the principle itself. Because when you have a source, you have to say to that source, there are limits on how you can conduct yourself. There are conditions, and if there's any sense that actually there is no limit, and you will always be protected, and you will always have that cover, because that's what's happened with Stakeknife. I think my own view, and this is one that again we've tried to articulate, and we're always happy to discuss and share with ministers, officials, and others. We actually think, I personally think, that naming Stakeknife would actually, it would support the principle of NCND, because it would show that it's not an absolute bar. There are extreme, and they will be tiny, there will be atypical conditions and circumstances where it is in the public interest, there's a greater good to name that individual. And if it doesn't apply in the case of the agent Stakeknife, I don't think it will ever apply. And I think there are dangers in that, because I think sources need to know there are limits on how you can conduct yourself. And grotesque, murdering, terrorist, torture and criminality certainly goes past those limits.
Alicia Keynes.
Thank you. Can I just ask, obviously we're looking at the legacy of an asset who behaved in that way, but do you have confidence that if there was a similar police informant or asset in any operational theatre who was behaving in the same way, far beyond the remit given to them and obviously committing acts of criminality, do you have confidence that lessons have been learned sufficiently that in a today context, without all the baggage of the legacy, that MI5 and the state would recognise that such an asset should be named in future or current situations again? Or do you think, again, the protection of assets, they haven't yet come to that balance that you're talking about in terms of public confidence versus protecting sources?
Well, my view is that they would stop that source acting. They would no longer continue to manage or to utilise or to deploy or to task that source. You know, again, we've always recognised this was an extremely complex operating environment in the 80s and 90s, certainly in terms of source management in the policing sense and other areas. It was prior to the Human Rights Act of 2000 and RIPA, the Investigate Powers framework that then came from that. And I think the management and the oversight now would be of such significance that it would never actually get to that extent. That certainly would be my wish, but I do think it would be my expectation around that. And I don't think, having spoken at length to colleagues in MI5, including the Director General, I don't think they would disagree with that. They recognise that as we sit here today, the conduct of that agent was outrageous. So my view is that wouldn't happen today. That's not to say that there would be continued issues with agents who have perhaps been deployed over a number of years, where some of those lessons have not necessarily been seen or been learned.
Thank you. Gavin Robinson.
Iain, can I just ask you about the sterility of what you've said? It's hard to consider these issues in a sterile environment, and you've outlined not a guarantee because you can't give it, but an expectation that with the legal framework the same wouldn't happen again. But is it not true that Stakeknife's value was found in the role that he had within the IRA? His value as an agent was the fact that he was head of the internal nutting squad, the squad that was there to root out informers. So is it not the case that if he were recruited and had to immediately stop, the very thing that made him valuable as an asset, then his value would diminish considerably? And that's the sort of complication in all of this, that in actual fact for him to be of value, he would continue doing those crimes that you're right to say are so heinous.
That I suppose, conundrum, as you outlined it, is one that applies to every single source. Sources are only of value if they actually have information, and by definition, most sources are not living, an entirely virtuous or crime-free life, because people who live such virtuous lives know very little about organised crime, know very little about terrorist organisations, and that's the information that rightly we as agents of the state and those seeking to uphold the principles of the rule of law, we need that information and intelligence. So that challenge around source recruitment and source management is something that is faced every single day and continues to be faced. So you capture the challenge correctly. The issue that we and I would assess with Stakeknife is that it went beyond those limits and parameters that you would naturally set. And this is in my view beyond any statutory framework that now exists. This is just in terms of actually, again, humanity and looking at his conduct, where his behaviours and his participation, that's a matter of stop. The state can't sit back and allow people to be tortured and allow people to be abducted and allow people to be murdered. It just can't, and I don't think it would happen now. But the challenge that you present is that, by definition, a really well-placed source has to be close to some of that criminality, and that's a challenge that will be getting faced right across the whole of the UK and Ireland as we're sitting here today in different fields.
As soon as a murderer whose job is to root out informants and murder his colleagues stops murdering, his colleagues are going to ask questions. Well, his value is going to be greatly diminished, and I just think, and I don't need to explore it too much further at this stage, Chair, I just think it can be quite sterile, it can be quite academic when you take these issues into a committee room or in the court, as you have done so. It's all what you think principle should be. And yet the real world, and the world in which you guys have operated previously, lawfully, I should add, and the world in which you're trying to police is not sterile at all.
Can I make a few comments on that? Only because, and it's just building on, I'm not disagreeing with anything that Iain said, but there's a legal and moral point about individuals who, on behalf of or with the knowledge of the state, commit serious offences, including serious harm and murder. So that would not be allowed to happen today. And going to the previous question, the mechanisms are in place, governance, oversight, legal frameworks, the checks and balances are there. That doesn't mean that you can allow for what human beings will do. But as Iain has described, I think anybody showing those behaviours, particularly with regards to the legal frameworks that the police apply, I think would be identified and dealt with pretty quickly and would be taken off the books, if you like. The issue, though, of what happened during the Troubles, the context has to be understood. And one of the things, to answer your question, Gavin, a little, is that, firstly, even during that time, it was wrong what was allowed to happen, in my view. And everybody forgets the fact that other agents were being murdered, were being tortured to protect an agent from other agencies. Mm-hmm. That was happening. I think we will never be able to properly appreciate, understand, and show our gratitude for the agents that gave information to keep society safe, and the security forces who managed them in that environment, because it was wickedly difficult. But there is a legal and moral framework where we know about protecting society that you do not pass. And because of the lack of training, guidance, oversight, those checks and balances didn't exist then. And in fairness to the security forces, we know, when we took testimony, people were asking for help from the security forces. They were asking for legal framework, and they didn't get it. And that's set out in the reports. But what I think you have to understand, and this relates to the question about the identity of the agent Stakeknife, you, I, the general public, have an assumption that when we apply NCND, we've operated within the rule of law. We've conducted ourselves properly. That hasn't happened here. So that assumption can be put to one side. There are arguments that have been made to me that the reason we can't identify the agent Stakeknife is that it would lead to an undermining of confidence in our security forces. The approach that's been taken all this time has undermined the confidence in the security forces. Every family I see say, was there collusion involved in this, John? And I'll ask them, what do they mean by collusion? Everything the security forces have done, and I think they operated in a way that we will never be able to properly thank them for. Overwhelmingly, they did a great job. But where we got it wrong, we cannot cover it up. We have to say we got it wrong. And that's not about blaming individuals. This is an institutional issue. And one of the previous questions alluded to, have we learnt the lessons? I believe we have, through legislation, guidance, framework, training. But publicly, in Northern Ireland, there is a significant concern that we haven't, because everything is still behind this curtain of secrecy. Mm-hmm. And the government talks about being determined to give more information to victims of the Troubles. In all the previous inquiries, those people I spoke to, and if you look at page 144 of the interim Kenova report, if you look at what Rennie Pomerant says about the security forces, they viewed themselves above the law. John Stevens said they covered things up, they didn't give me intelligence, they didn't give me information. They willfully obstructed me. So this constituency read all of that. And then when we are not making decisions to name this agent, it's seen as a continuance of that position. And with the new legislation, and we'll probably get into it, some of the things that have been put into that legislation around information provision probably reinforce those concerns. So we have got to look at this in the round. And the public interest point that Iain made at the beginning of answering the question about Stakeknife has shifted. These reports have shifted it. Around now, it's in the public interest to name Stakeknife, in my judgment. And I'm hoping that the Secretary of State will listen to those arguments. The last thing I say about that is that we mustn't forget those agents who were murdered, because no one's talking about them and their families, who then suffered and still suffer because of the label of having a family member who's accused of being a tout, and a number of them were not. And by the way, the IRA didn't care. The IRA did all this because it was deterrence. I think we've both had to reframe, and the Kenova team, our understanding of what awful things one human being will do to another. This was about subjugating and controlling that community because of the success of the security forces with agent penetration.
Absolutely.
And what they did was beyond vile. That's the leadership of the IRA and the Internal Security Unit. That should never be forgotten.
Jon, you mentioned about the Secretary of State. Is there anything more that you can do in your capacity as Chief Constable to encourage the government to name Stakeknife?
So I've obviously had conversations with the previous Secretary of State, who had a great relationship, and this Secretary of State, who, by the way, I have to say they've got such difficult jobs. This is really hard territory. This is wired in culture about not revealing this information, because there is this, I think, misplaced position that it will undermine public confidence. As I've said, I think that's the wrong approach. I had an exchange with the Secretary of State, who I have huge respect for, between Christmas and New Year. We're going to get a meeting very early on. I know my office have actually emailed his office to have that meeting about a number of issues. And I wrote to him just before Christmas to say we need to talk now about the naming of the agent Stakeknife. So that position of presenting the case to do that is continuing both by Iain and by myself. But and obviously I think Iain used the term in the release of the Kenova report when we spoke to people then, we are not constitutional values. We will apply the rules, we will apply the laws, we will act properly. In this instance with Stakeknife, people didn't act properly. So please, let's now put that right and act properly. And that's the arguments we're making to the Secretary of State.
And Sir Iain, I mean, it's widely known what the name of Stakeknife is. It's been mentioned in the chamber, it's been mentioned in this room, the name of Freddie Scappaticci has been mentioned. And as I've asked Chief Constable Boutcher, now that Kenova has concluded, do you regard it as your responsibility as well to continue pressing the government to name Stakeknife? Because it seems like a farce.
Yeah, I do consider it my responsibility. I think I've got a duty, I think, on behalf of the work that Kenova carried out, and the families who have a strong expectation that Stakeknife would be identified. But you know, as we said with that phrase about, you know, we're not vandals, we're not here to bring down the structures and the institutions, because we're part of them. We are intrinsically part of that system. But in some ways, that's why we're so determined, so committed for that system to work in an ethical and in a manner that commands public support. The legitimacy of any state agency, whether it's intelligence or law enforcement, can only come from the support of the public, ultimately. And certainly in Northern Ireland, my observations are that this continues to be a major obstacle to that level of support and legitimacy. So I haven't spoken to the Secretary of State over the Christmas and New Year period, but I've been in touch with his officials. He has given an undertaking in correspondence with me just towards the end of last year that he would give a determination on our request to name the agent Stakeknife on the conclusion of the Thompson case, which obviously has now concluded. So my expectation is that I will have correspondence from the Secretary of State in due course where he will directly address that question. But I've offered a number of times to his officials, I've offered in correspondence with him to come and meet and speak, because I understand entirely that there are numerous organisations, agencies, operating environments that will have interest in this issue. This is not purely a matter that sits within legacy issues within Northern Ireland, and therefore I would wish for him and for the NIO in general and others who are considering this matter to really have that sense and feel the knowledge and the impetus behind naming him. And ultimately, it will be a matter for ministers. I have taken a view that we received information, and it's outlined in the final report, on clear conditions that we have to recognise and we have to uphold. And it is a matter that ministers should take that decision, but I think ministers should take it in the wider public interest and name him. So, although the final report has been published, we're not going away in the short term, and we're going to continue to advocate for the recommendations.
Thank you. Paul Kohler.
Thank you, Chair. I'm going to return to something Gavin mentioned. Given Stakeknife's role and the awful and terrible contradictions inherent in maintaining his cover, wasn't the real mistake recruiting him in the first place?
So again, there'd be a subjective view on that. My own view on it would be, I don't think there was a mistake in recruiting him. Again, coming back to some of Gavin's observations, that an individual who's as well placed or as close, and of course he grew within the command structure within the IRA as he became an agent. But his initial recruitment, based on what we know and based on what we found out, I think would have been legitimate. I think it's thereafter, as he's risen through the command structure of PIRA, that I don't think thereafter there was enough oversight, there was enough checks and balances. Nobody stepped back and said, hang on, this guy's now gone beyond any level of decency or proportionality. But I would struggle to say that his initial recruitment was wrong. I think I could understand why he was recruited, and we're coming back to how difficult it was, that environment, and intelligence was the lifeblood. So his initial recruitment, I think, was probably legitimate and understandable. I think it's what happened thereafter, but I mean, John may have a view as well.
No, I think I accept that. I think that because of the times, the security forces were desperate to get information to try to protect society. And the longer somebody is as we now call CHIS, covert human intelligence source, the more likely it is that they are going to progress within an organisation, and that's what happened. But in fairness to those members of security forces who were managing Stakeknife, and I've alluded to this, they weren't having the guidance and the oversight and they were asking for it that they needed. So, and I've used this terminology in the interim report, they were operating off the books because they were just trying to keep society safe. There's a couple of wider things, though, I think I just want to mention about the naming of Stakeknife, if I may, just because of the previous question as well. In Iain's report, there's a section, I think it's section 9, where he sets out when Stakeknife was first referenced, which was 1999, I think it was Liam Clark, a journalist, and that was Ian Hurst, who was an ex-member of the FRU, Force Research Unit, who was then using a pseudonym, who introduced that there was this agent Stakeknife. We then moved forward, and various occasions, Stakeknife has been associated with the Freddie Scappaticci, including by members of this committee. You'll recall that Sir John Willsey, who was a previous general in command in Northern Ireland, he was duped by Hurst, and in a recording says in a recording says that Freddie Scappaticci Stakeknife. In Iain's report, Freddie Scappaticci, we know from our inquiry, told his wife that he was Stakeknife. He told a female associate that he was Stakeknife. With all of that and the issues we've already discussed about the conduct, morally and legally, of what he did, the argument is so compelling, but there's a final reason I want to explain why it's important. The PSNI are going to be recruiting this week. I am desperate for this society to move forward. All communities, not just the two traditional communities, all communities. If you look at any of the news outlets in Northern Ireland, a week does not pass by where there's not a mention of a legacy case. And because of our approach to this case and others, and I'm not talking, I was head of covert policing, undercover policing, I've never breached NCND. That's why we're answering these questions as we are, and I'm not breaching NCND now. But the nationalist community see this as a continuation of what's always happened. Protection of wrongdoing by the state. I can say categorically, the families I've spoken to, I have explained how much the state did to protect their loved ones. But in this instant, we got it wrong. And to help society move forward, to help me get Catholic officers into the PSNI, we need to start making some difficult choices. And each Secretary of State that I've dealt with, and I've dealt with a number now, get the same advice. Doesn't matter which the government is. And they take that advice. I'm just asking, please listen to other people who have some considerable experience and understanding and more accountability in policing than in the intelligence agencies. We're in the front line there, day and daily, overtly, to get the support that we need. These decisions have another importance to them as well. And I think that's important to mention. By the way, I also want young members of the Loyalist Unionist community to join the PSNI because we've got problems there. But we've got to deal with some of these issues rather than sit by and let things just pass by.
Thank you, Chair. Just really, really quickly, is there any risk that naming him would put any active agents or family at risk of repercussions in any way?
So because of the background of this particular case, I am very firmly of the view no. Okay. What we would always do in these cases, and there's been other cases which are worth mentioning, Declan Casey was revealed as an agent. Brian Nelson is the most important one that people know because he was an agent for the Force Research Unit in a similar way to the agent Stakeknife. Interestingly, in that case, and I've read all the papers on these cases, David Cameron came out and praised Paddy Mayhew because he was under considerable pressure not to prosecute Brian Nelson by other government departments, government lawyers, same pressures that we're seeing now. But he said, as a lawyer, that legal moral point, the public interest, as a lawyer, we need to prosecute this individual. And the sky didn't fall in. We didn't start losing agents. Agents didn't walk away. We didn't find ourselves that we couldn't recruit agents. And very recently, in a case that I was involved with, which was the Sean Brown inquest, we provided a gist. And that just didn't mean that we lost any agents. Now, what I will say is the Secretary of State, the government lawyers, there are outside elements, international challenges that they also have to consider. Will that have an effect? I find it, though, hard to believe that internationally, whether it's China, Russia, Iran, that people are looking at us naming the agent Stakeknife because of this history that means they're not going to work for the security forces. But I'm happy to listen to arguments to the contrary.
Okay, thank you. Now, you've both said that you've had contact with the Secretary of State. Has that been in light of the Thompson Supreme Court judgment and in relation to the policy of neither confirm nor deny?
So no, we've not had a chance to do that yet, Chair. So I wrote to the Secretary of State. We had an exchange of letters waiting for the Thompson case. We've got a new PII policy. We released it in December, and the judgment sets out that I'm entitled to do that. And I want to sit down, I think, and I'm not criticising them because this is a difficult space trying to change hearts and minds and attitudes. We need to sit down. I would do nothing to damage national security. If I have a difference of opinion with the Secretary of State on his advice from lawyers about an issue that would be related to NCND, he quite rightly should go to a court and explain his concerns, and the court, as the Thompson case said, should take note of what the Secretary of State said, in precedent in a way, over what I might say. So I don't disagree with that. I really don't. But we need to get this policy in place, which, by the way, we've published again, so that people from all our communities can see how we're dealing with sensitive information. That openness that we've not previously had in Northern Ireland, which we have elsewhere. But we will be having those conversations. And I think it's only right that we have those conversations before we probably report back to the committee.
And so, Iain, are you expecting to have further engagement on this issue?
Yes, absolutely. I think the Secretary of State intimated that he was almost reserving his position until the Supreme Court had issued its decision in Thompson. That's now been published. So I would expect to either have contact, certainly communication with the Secretary of State and his office. And as I say, we've reiterated, and both of us this morning are stressing that, that we're more than happy to come and speak and brief officials, brief ministers, talk to them, give them a perspective to add to their awareness and their knowledge for recognising the pressures they're under. But there is a perspective that comes from Kenova that I think is not always provided from other places.
Do you think that the Supreme Court judgment on Thompson will influence the government's position on naming Stakeknife?
Can I mention on that, the Thompson case, and obviously I'm close to that case, isn't about naming agents. I know the Secretary of State made statements about waiting for the Thompson case. It was about gisting that was done by a coroner. I initially didn't support that coroner because of the nature of the gist, then I did. And that was challenged by the Secretary of State, who often says, and I understand why, and I would support that, let the courts decide. That decision by that court, that inquest, that coroner, the Secretary of State, obviously under advice, challenged. That judicial review went in favour of the coroner. We then went to the Court of Appeal in Northern Ireland, and that decision went in favour of the coroner. And then the Secretary of State sought leave to appeal to the Supreme Court. And I support the Supreme Court decision. The Supreme Court disagreed with the courts in Northern Ireland on some aspects. But that was about gisting. It's not about the naming of an agent. It is very different, in my view, in my humble view. It's about the ability of the security forces to provide a gist, but it should have a primacy, if you like, decision maker with the Secretary of State. It wasn't about naming agents.
How did you feel after the Thompson case?
So, if I'm frank, and by the way, I think there'll be more cases. I've been involved in a number of cases already in law enforcement where we've changed the weather, we've done things differently, and courts have supported us. And there are other cases coming before the courts. But I think it provides clarity. I think it shows that the Secretary of State should have this overriding decision-making process towards the court. The courts can still decide to disagree. We are subject to rule of law in the courts. But I think it has helped us all have a better understanding and will provide more clarity as we move forward. And I'm very happy to listen to lawyers from the security forces, from the government, around anything that they think we need to change around the public interest immunity policy that we've written. But it doesn't, I think, particularly help the Secretary of State. If I'm candid, I think this debate probably helps more around the naming of Stakeknife.
Could I just briefly add that, again, there'll be greater minds than ours, I'm sure, but I don't see anything in the Thompson judgment that precludes the Secretary of State taking a decision to name Stakeknife. So as John outlined, it wasn't, it didn't stand on the NCND issue. That it always had relevance to in terms of the gisting and who ultimately had the authority, as John outlined, almost a hierarchy. But as I read Thompson, there's nothing within Thompson that would stop the minister given authority to name Stakeknife, would be my interpretation of the judgment.
Thank you. Gavin.
Thanks very much, Chair. When you gentlemen were with us in April, I asked you whether you considered it bizarre that we were having this discussion about naming Freddie Scappaticci as Stakeknife, and I think it was you, Sir Iain, agreed it was bizarre. When you launched your report before Christmas, I think you went as far as you could in saying that Freddie Scappaticci was a person of significant interest to Operation Kenova. And John has referred to some of the references in the report, which, if somebody wished to get the gist of what was being said, they could. Did you speak to Freddie Scappaticci as part of Operation Kenova investigations?
Yeah, we interviewed Freddie Scappaticci on a number of occasions, yeah.
And how much is that referenced within the report?
I don't think the report goes into the details of what was said. Very little was said in the interview, that's the first thing. It was important, I think, for the families to know that cases that we're investigating where he was a suspect, as with anybody, that he was interviewed under caution in the ordinary fashion, which hadn't happened before because there's been previous examinations into his offending, which haven't been dealt with as we would have expected them to be. But what we did do is we informed the families when he was arrested that he'd been arrested because of this openness of the investigation. But what we've been very careful to do, because we've got an obligation when we're giving information to comply with that confidentiality. And I know, you know our position. We think it's become pantomime, farce, call it what you will. I think it's more, I don't like those words in a way though, because it's so important for society in Northern Ireland that we revisit this decision and I think change it because of the confidence in government, the executive, by our different communities. But we can only make the arguments that we can make. My own view is that he will be named formally. My frustration is we're wasting time that is unnecessary, and it should already have happened. And in a way, and forgive me for this because I need to be cautious what I say, I just think at the moment, and if you look at the interim report, all of the people who dealt with previous legacy cases talk about the frustrations of not getting information, being misled, being obstructed. At the moment, the people who are involved in that, those roles are the ones that the government are listening to. Yeah. And the final thing, can I just say on this around the agent issue, is those agents, I think, when they agreed to work for whatever agency, the military or the police, generally it's the military or the police, I think if they were at risk, they would have expected for us to do everything we could to protect them. I think that's a reasonable thing. We didn't. To stop this individual Stakeknife from being identified, we allowed people to be harmed and killed who had put their lives at risk for the state.
When you spoke to Mr. Scappaticci and what we've considered as official confirmation or denial, did he accept that he was Agent Stakeknife? Do you know what, Gavin? I honestly, without having the material in front of me, he went no comment to most of what was said. I think, from recollection, he did not. But what I have said, and it's in the report, he told his wife he was the Agent Stakeknife, and he told a female associate that he was the Agent Stakeknife. I'll check that and come back to the committee if I may, or ask Iain to. But I don't think he did. Just finally on Thompson, and I think it draws from what the chair was asking and the implications of it. Dennis Bradley is a well-regarded individual in Northern Ireland, heavily involved in engaging with Republican paramilitaries as a priest to bring them to peace, and with the wider nationalist community too. He was the first vice chair of the policing board. He is somebody who has spoken very powerfully about truth and reconciliation and believes there should be a truth and reconciliation process, save for information around informants, because he believes it will destroy families, it'll set brother against brother, sister against father, it'll destroy families and destroy neighbours and destroy communities because the truth will be known. So whilst we're talking about this specific case, is Dennis Bradley's broader point something that both you and Sir Iain agree with?
I think I've got huge respect for Dennis Bradley, and I meet him. I went to see him when I started Operation Kenova. I would always listen with great care to what Dennis Bradley says, and from what you've described, I would concur with some of those comments. This is a very specific case. We very rarely step away from NCND. I gave you a couple of examples, but I would sympathise with Dennis Bradley's position. And that would actually step into territory of people not potentially agreeing to become agents. So then we would, Iain and I wouldn't be able to make the arguments we're making now. So from the way you've described that, I would have sympathy with that position, yes.
Thank you very much.
Just in the back of the answer that you gave Gavin about interviewing Scappaticci, it actually says in the report it has not been possible to deal with the full facts surrounding the agent Stakeknife and the late Freddie Scappaticci in as full as detail as hoped. So can I ask, is that in regards to NCND, or is there something else there?
So, if I may, and Iain may want to come in, when we wanted to talk about the investigation, Freddie Scappaticci is a member of the Internal Security Unit and has been interviewed for offences regarding that. If we want to talk more openly and publicly about that offending, because it was a small unit, and there are other cases that are synonymous with the person who's identified as the agent Stakeknife, we effectively would breach NCND. That's what we would do. So we have to walk a bit of a tightrope in how, and it's probably relevant to say, when the reports are published, they go through, we wrote a protocol, which is a stepped process before the report is published so that all of the agencies agree. And one of those processes is security checking. So the lawyers would say, if you were to describe those cases in that way, and this happened with Iain went through this process, because in this report Iain has produced, there's evidence of particular crimes and what was done. And I know there was a lot of legal input in how that was described, so as not to breach the NCND position with regards to the agent Stakeknife.
Yeah, I mean, that part of the reason, and there are numerous reasons, I think, about my ambition to publish this final report was probably, turned out to be greater than my abilities in the end, I think, when I came before this committee before. But part of that was not only some of the intervening facts and circumstances regarding MI5 material and other issues, but a big part of it was to do with the security checking process. I mentioned that in the report, that again, an early piece of learning that Jon took, that collectively Kenova took from those that had gone before, was that when the work's concluded, nothing comes into the public domain, by and large. And therefore, this determination that part of the Kenova philosophy, the Kenova ethos, would be to publish public-facing reports and share as far as possible, notwithstanding any prosecutorial decisions that may or may not have been taken, but to public in the public interest, as a statement of intent was right and was very clear, but actually it was really, really complex to deliver. Really complex. And again, back to my opening point about frustrations around it. So that point in there, Robin, about, we can't tell the full story, is because we're constantly saying, well, that applied to Frederick Scappaticci, that applied to the agent Stakeknife, and we can say this about Scappaticci and we can say this about Stakeknife, but we can't merge the two because at this stage we're still precluded from any level of confirmation on the identity of Stakeknife. So that's why that caveat, if you like, I included that within it, because people may read and think, just as you have this morning, almost ask for more information and more detail around it. We've been as open and full as we can. We've included the summary of the cases that were submitted. We've included the circumstances of Stakeknife's management, recruitment, relocation, etc. All of that was really challenging, dealing with people who had a legitimate but at times alternative perspective, and we always wanted to make sure that we would get as much into the public domain but recognise legitimate national security challenges. But it has been really hard work to do that and to get as much information into the public domain as we've been able to do.
Okay, Katrina Murray.
Yeah. Thank you both for coming back. I want to look at the information sharing and various protocols. Like yourselves, I've spent my entire working life within the public services, so I understand the practicalities of how information gets siloed, and particularly worked in medical records in the 80s. So I know also the challenges of what would be paper-based records. Within that, was there any constraints on the information and intelligence sharing arrangements that you had in place with PSNI, MI5 or the MOD? And the MOD?
So if I start, and obviously because I began the investigation, I think at the beginning everyone was very nervous about sharing information. I mentioned that I'd gone to see people who led previous legacy investigations, and they all said there was always a problem getting the information. And there's one of our colleagues who sat on one of our oversight groups, John Miller, who is the Deputy Commissioner in New York Police Department, said, if there's a problem getting the information, John, it's because there's a problem with the information. And there is something, I think, to what John said there. But I have to say, because of what I was told would need to be a critical success factor in getting the information, we didn't get it to it straight away because there's no model, there's no legislation. We built Kenova on the backs and experiences of others. I was confident as I could be that we had got unfettered access to all the information. With the PSNI, we got that pretty quickly because the Chief Constable had commissioned this, who was Sir George Hamilton, so he was very supportive. There were concerns about Kenova from some of the PSNI about the oversight groups and the access to information, but they were understandable and we had to show that we would handle the information properly. The MOD, they had information in so many different places. It wasn't audited, it wasn't catalogued, it was mainly in analogue form. And the security service, you know, I describe in my report, we had some real challenges with. But I thought we got to a position and we had a memorandum of understanding and a protocol, information handling protocol with them that I agreed with the Director General, now Director General, Ken McCallum, and I thought we got to a really good position, I have to say. What I have to mention, though, is when the 2023 Legacy Act was written, in there, Schedule 8, talked about this new proposition that every document that was provided to the ICRIR would have to go through this assessment process around classification or sensitivity and prejudice. Now, I've only ever been really a detective. I've never seen that provision in any legislation anywhere. And I talk about snakes and ladders, about investigations. As you're making progress, I felt something was being put in the way of the ICRIR getting unfettered access to all that information. And if you correlate that with the comments by those people who previously led Legacy about not getting access to information, this isn't about the security forces, by the way, it's about the legal approach. I think the security forces were remarkable. And that is something I'd not previously seen. I made representations about that because I'm worried about the future. I'm worried about the success of the legacy framework going forward. And in the latest Troubles Bill, Schedule 4 mirrors, from what I can see, Schedule 8. And I simply want to give, for me, and this is about trust and confidence for all the communities in Northern Ireland, I don't want to get in the way of that information as the PSNI Chief Constable. I want to be able to say to all those communities, the keys for all of that information has been given to the Legacy Commission, who've got commissioners in charge. The Lord Chief Justice currently is the Chief Commissioner for the IC, or ex-Lord Chief Justice, forgive me. Who better to manage sensitive material? I'm happy for them to defer to us if they're going to put something in the public domain to say, we intend to do this, like we did with the Kenova Protocol, the security checking. But those determinations, they'll delay the process. They're costly, and we're not funded in the PSNI for Legacy, so that's a whole separate issue. That will slow things down. So I wonder if there's a collateral reason for that. But importantly, they will suggest to families and victims, or they risk of suggesting, there's another hurdle in the way that the police that potentially they didn't trust are now making determinations about information. So I don't understand it. And I think it risks the success of Legacy moving forward.
I think you're right to highlight the importance of information sharing. You know, as you'd say, in all many elements of public life. You know, over years on child protection cases, on domestic violence cases, subsequent reviews or have pointed out that actually the information was held somewhere, it just wasn't shared in the right place. This takes you back to Sir Michael Bishard and other places, and the health sector has seen similar issues arise. So in terms of stepping back and taking some of the learning experiences from Kenova about what should be set and hopefully into legislation going forward, I do think those issues around information sharing are critical. I think there's I include a section 8 in the final report, accessing information, and we go through each of the agencies, and we give an example of a database called MESA at 8.7 in the report, whereby where you ask for information and people acting in good faith then give what they think they have, but actually there's more than that. You had the HET, who were actually although they were distinct, they were still part of the PSNI, and they were not provided with all the information that the PSNI actually held. And the HET were populated by extremely experienced detectives from different forces across the United Kingdom who had gone in as an independent unit. But they did not receive all the material. It was only when the Kenova team came in, and again we outline how it was by accessing information, having that direct ability to interrogate systems, that Kenova were able to attain that information. And as Jon outlined, I think that is one of the challenges of, as I read the bill compared to Kenova, is this sense that the person who you make the request of, or the organisation who you make the request of, still has to do that assessment process on sensitivity, where actually the investigating agency, give them the authority. They're the ones who know what they're looking for. They're the ones who know best, and the experience. If Section 8, although some of those issues are relatively dry compared to some of the other sections, I think it is really, really important in terms of lessons learned from Kenova going forward, and I think that access of information is crucial if the reformed legacy commissions to make progress.
Within that Section 8, you also make reference to the difficulty processing evidence from the MOD.
Yeah.
What improvements should be made to the way it manages it and catalogues its documents?
The MOD, again, in your opening question, Chair, you rightly said paper records over many decades, records over many units, agencies, regiments, structures, entities and whatnot. I actually think, legitimately, that colleagues in the MOD benefited from Kenova coming in. So Kenova came in and actually have said, well, actually, we can assist here. And I think I mentioned within that, I don't know how the MOD have taken it forward, but we all know that all agencies in public life are faced with this challenge of moving from paper and moving from analogue into digital. And again, that it was a consequence of that. That was one of the reasons that, in fairness to MI5, that actually MI5 ended up discovering some new material, was because, as they outlined to us, they were in the process of doing this digitalisation. So I think all organisations are challenged by it. But again, I think Kenova has been a driver for some of these improvements.
Picking up on the MI5 references, both the former PSNI Chief Constable, Sir George Hamilton, has recently suggested that there should be an independent judicial review of the sharing of MI5's intelligence with Kenova investigators. Do you agree with that?
I'm not sure that... I don't know, to be candid. And I think, as I recall, George gave an interview, I think the day after we'd published the final report, and it was on a discussion programme where he was asked to assess the implications of it. I think, what I would interpret his intent behind it is to say, we can't just sort of nod and move on from it. We need to make sure we've learned from it. My judgment in terms of the approach to the Director General and the current leadership of MI5 is that, that resistance is something that they would not support at all. That, this came, when this material came to light, they were as shocked as anyone. And again, if you were very cynical, if there was a real need to suppress the information, they would never have told us in the first place. Who would ever have known that the found new material had, the current individuals within MI5 not presented it, knowing that the organisational embarrassment and criticism that would bring. So I think there needs to be a recognition that they did that, and the Director General put resources into establishing that material. And again, I've absolutely no doubt, as I said, as we move towards digitalised records and whatnot, that a lot of the approaches will have changed with this. And I think it's also important to recognise that MI5 had far greater knowledge of Stakeknife, far greater knowledge than they told us. They were involved in tasking, strategic and tactical, in my judgment, at quite an early stage. But he was not an MI5 asset. He was a military asset. He was an army agent. But the MI5 role in it was far greater than we had been told initially. And this new material was really quite significant. But as I say, it was MI5 themselves that brought it to our attention.
Chair, can I mention one thing? Sorry, just because it's the Mesa point. With the Mesa, and Iain describes it in his reports, in the interim report, I don't think there's any malign intent there, I have to tell you. We identified that because we got the keys for the Mesa database and there were codes to access it as Operation Kenova. And then we understood that the MOD, who'd passed over the Mesa database when they withdrew on the 31st of July 2007, I think that they withdrew from Northern Ireland, so that the responsibility for the database they left with the PSNI. We then realised there was a set of keys to the Mesa database that the MOD had and would use for their civil cases and litigation. So we got their keys, and if I describe it as a 5-drawer filing cabinet, the PSNI keys opened the first 4 drawers, the MOD keys opened all 5. And we had to point that out to the PSNI, and the Chief Constable of the day had to write to the presiding coroner and others to say, when you've asked us for information, there is a bit of a problem because we didn't realise there is information we potentially have not provided you with. Now, with legacy moving forward, because of this element of Schedule 4, we can't get this wrong. We can't have people mistrust or distrust. There is a distrust in the police from some people. So to give them absolute direct access, unsupervised access, they're the best people placed to decide any prejudice. They're the best people placed to decide sensitivity of those documents because they'll see them in the round. It actually isn't the PSNI years later. So it's a really important point around legacy succeeding moving forward. And at the moment, there's a deaf ear to the points that we're making.
Just picking up on that, it is absolutely critical to the success of the proposed Legacy Commission, any work on legacy going forward, and actually a confidence across the entirety of Northern Ireland that we've actually dealt with it. We've got the answers as far as we need. What is your approach of the assessment of the MI5 approach to legacy cases in Northern Ireland, and does it need to change?
So I've mentioned this. I do think there is an issue, I have to say. I think it's a cultural issue. Listen, I'm the biggest advocate for MI5. I've worked really closely with them in tackling international terrorism. I spent years working closely. The Director General I have huge respect for. He's a personal friend. And we've talked about these issues. I'm now the Chief Constable of PSNI, and some of the things I've said today wouldn't be under his consideration because he has a different role. And we're the police, and as I explained earlier, I mentioned this, we're far more outwardly accountable, which is right. Coming out of conflict, as we are in Northern Ireland, we have to work doubly hard to be human rights based, open and transparent. We have to make sure we've got really robust accountability measures. Intelligence agencies don't work in that same way. Even recently, there's a proposal in legislation about having a duty of candour for public services, which I support in general. But the intelligence agencies, I know, are concerned about that. There's a difference. So I understand why they would be reticent and hesitant. But what I don't think they've done is listen to the arguments we presented, look at the history of those reports that are mentioned in the Kenova interim report, and necessarily understand the importance of moving society in Northern Ireland forward, because they've got much broader and wider issues as well to be responsible for. But I think this session, Sir Iain's report, the conversations we have with Sir Ken, I think all of it is moving the dial. But do understand that they have a very different role and function from the PSNI, one which I respect, and they've got a wickedly difficult job. We've just got to find the right sweet spot, if you like. But I do think they need to change their approach around information disclosure in helping us with legacy in the future.
Thank you. Gavin Robinson.
Thanks very much, Chair. The word conspiracy has been used already in this session, and very often you will hear people in Northern Ireland talk about the quest for truth and justice. And one of the things that I think you have both highlighted as a benefit of Operation Kenova is the personal relationships that you've built with families. And that sometimes involves indicating to a family that their truth is not the truth, that the assumptions they had are not borne out through evidence, and therefore are left in a position that sometimes the truth doesn't lead to the justice that they seek, and there is a level of disappointment. And so there has been a disappointment around Operation Denton, you'll know, with some of the families, and the finding that you've reached that there was no systemic collusion with loyalists involved in that attack, or those attacks associated with the Glenanne gang. How do you wrestle with that, and how do you conceptualise the disappointment for the families? Are they right to be disappointment, or is the fraught nature of legacy simply that when somebody has a truth that's not borne out by the truth, there's inherently going to be disappointment?
John, I'm sure will add to it. My experience of that, Gavin, and again, I'm grateful for the question, has been that is enormously challenging. When you sit down with families or a group of families, and you look them in the eye, and you've heard their trauma, you've heard the fact that they've lost a parent when they were young, or they've lost a spouse or a loved one, and they've had a view, or they've developed a view, or others have presented them with a view or a perspective on what happened, and they've held to that almost for years, if not decades. And what we have done, and had to do, was explain. This is why the process and the steps we took, and the length that we went to, and the depth that we drove down to, was important to explain to families as well. Is that we have gone beyond previous inquiries. We've stepped and gone and spoken to challenged individuals. We've looked for perspective. We've looked for information that wasn't necessarily available previously, and this is our legitimate finding. So the family of Jean Smith Campbell, which is our Operation Mizzenmast, Jean was tragically murdered in 1972 in West Belfast. Her family have always been of the view, because there wasn't a full investigation at the time for all sorts of reasons. I think that particular time in 1972 in West Belfast, probably one of the busiest weeks or fortnights. It was the troubles were just absolutely horrendous, and the challenge for policing and law enforcement was really, really significant. But Jean's family have always said that Jean had been murdered by the British Army. That was a hypothesis that they held to and felt was right. And so much so that, as you know, they progressed it, and they were successful in a judicial review instructing the PSNI to reinvestigate it. And that was one of the other additional cases that came over under John's then leadership to Kenova, And again, as I said in my preface to the report, because of the integrity and legitimacy that Kenova had established, that's why it grew and took on those additional responsibilities. So the Kenova detectives, again, I mean, people of the highest calibre, I've got to absolutely reassure the committee on that in terms of the quality and the experience that the detectives involved in this work had. They then went through the reinvestigation process, and our finding is that we can't get it to a criminal standard beyond reasonable doubt, but everything that we have found and investigated, we are confident on the balance of probabilities Jean was murdered by the IRA. There was a shot by, and there's all sorts of circumstantial reasons, ballistic reasons, evidential reasons that are aligned with that. Jean's family still do not accept that, and we recognise that. We recognise how difficult that can be. But our job and our responsibility is to present the facts and circumstances as we have found them, and at least say to family, this is what we've done. We've done something that's never been done before. The outcome and the answer might not be what you had thought. And again, that's why I think even in Jon's interim report, he makes it clear how damaging speculation can be, and often there's speculation and alternative hypotheses are presented almost for the interest of the person doing it, as opposed to the interest of the family. And similarly, where we had meetings with the families of those slaughtered during the Dublin and Monaghan attacks in 1974, when I'd said, horrendous attacks. We haven't seen any involvement of state agencies in those attacks, and that ran contrary to views that people had held for many, many years. But if you are as open and transparent as we have been, you're physically there with them, you've met them, you've developed relationships, you explain the steps that we've taken, you explain that the fact that there are gaps, it's not definitive, there's always gaps when you're looking over decades, but this is our professional view, and in all honesty, integrity, we need to do the right thing by you as families and victims, and we need to tell you what our findings are, even if they don't align with what you've previously felt. But you're absolutely right to highlight how challenging and how difficult that is.
It's important. Sorry, Gavin, I was just going to say, whoever shot Jean, and on the assessment of the Kenova investigation, it was more likely to have been an IRA gunman than a member of the security forces. They didn't mean to shoot Jean Smith-Campbell. She was an innocent woman, young mum, living her life, doing nothing wrong. It's that adage that she was in the wrong place at the right time. I like to say she was in the right place at the right time. The gunman and those people perpetrate these crimes were in the wrong place. They shouldn't have been there. But she'd done nothing wrong. And just to slightly illuminate that story with the family, who are incredibly, incredible family, we had probably the most experienced pathologist in the United Kingdom look at all of that case. He actually commented to the family that it was the most comprehensive review of a cold case, if you like, that he'd seen. We had photography experts because there was a concern, you used the word conspiracy, that's why I want to make this point, that the security forces had doctored, had altered evidence deliberately to ensure that wrongdoing by the security forces was covered up. We were able to show that what they saw as suspicious actually wasn't suspicious. We gave them an actual practical demonstration of what had happened to cause them to believe that. We also had the finest ballistics expert in the UK talk about, and it was obviously very challenging, what had actually happened on the day, to show that another theory they had about multiple gunmen and the nature of how Jean died was wrong. So it's just important to say the family, I think, accept and understand the rigour that's gone into this, but still have a contrary view. And that's why I think at the time we agreed not to say too much about the case when we, or when Iain released the report just before Christmas.
Well, fair enough, and thank you for that added information. I'll just go back to the exchange you had with Ms Murray around MI5 and intelligence sharing. And there were some reports, Chief Constable, before Christmas, indicating that MI5 were in a position of ending the sharing of information with PSNI because of their concerns as to how it's handled. It is accurate that that was reported, but is it accurate that that's their position?
No, it's complete nonsense. It's one of those things that, you know, you look at, you worry for a second, of course, but listen, we've got a really strong relationship with MI5. I've worked with them so closely. I've explained my relationship with the Director General. We're extremely close friends. I have great regard for him and his integrity and the way he conducts himself and the way he's trying to run that organisation. And there is no issue with PSNI and MI5 and exchange of information. As ever in Northern Ireland, you know, you often get stories that are just not based on any fact, and that I can absolutely categorically say is wrong.
I'm quite glad I asked it the way I did then. Otherwise it would have been quite embarrassing. Anyway, how do you now view the decision during Denton to share the names of alleged paramilitaries with victims' families, given some of the issues that have arisen and been before the courts, I understand?
Again, a very pertinent and relevant question. I'm restricted slightly, Gavin, because it is, as you say, that there are live judicial or challenges that have come in seeking judicial reviews, challenges that are against both myself as the head of Operation Denton, you know, which is part of the Kenova suite, and then also Chief Constable Boutcher, because ultimately he has responsibility for Kenova. So there was a hearing in Belfast on Monday. Because of the issues involved, a number of agencies have now, I think, have come involved, the ex-parte, a phrase I would be familiar with. I don't know what the specific term would be. So at the moment, you know, we have published the conclusions, the findings, strategic findings in the final report. That itself was subject to a challenge. The weekend before we published on the 9th, there was an application for an injunction to prevent that publication. But in the section on Denton, as you'll see, we outline the approach, we outline the background, we outline the amount of information that was researched to inform the work that was carried out, and we then give our findings, a number of which you've mentioned already today, but no individuals are named within that. And again, thankfully, that allowed us to get that information and you know, really up to the deadline, really on the Sunday and the Monday before we published on the 9th.
That was sort of confirmation given to the court, and in light of that confirmation that you wouldn't name, then the judge decided not to find.
In terms of interim relief, but the substantive issue now, because again, coming back to what we said at the outset, and I've already alluded to it, that we, you know, through Jon's determination and you know, initiative, something that I absolutely agree with and have sought to implement and continue. You know, we want to put as much information in the public domain as we can. So the full Denton report itself runs to, I think it runs to about over 150,000 words. It's a significant piece of work, and the victims and individuals of the cases that had been reviewed are memorialised, and the issues that have arisen, the specific attacks and the linkages are analysed, and a narrative is provided. I think it would be a really significant document, I think, of even of the history of the Troubles, far less the work that had been done. But within that, inevitably, there are individuals that are named. So we are going through a process at the moment round about representation and you know, a sort of that broader point of maximalisation, as they talk about, if we're criticised. It's very complex in this instance because of the amount of work involved, and then we're still facing some of the legal challenges to try and prevent publication. But our starting point, and you know, is we want to publish as much as we can. And until we're told not to, we're going to continue to try and progress that, because ultimately we think it's in the public interest to do that. But there was a sense of relief that we were allowed at least to get the strategic findings into the final report, so we've been able to discuss them, just as you talked about today, about the fact that, you know, we saw horrendous elements of collusion amongst state actors, but it was, you know, as I would describe it, it was at an operational level. It wasn't at a strategic or a political level. And a lot of those instances had already been established before Denton was initiated.
we've had a discussion about sharing of information and a rebuke to the notion that was published in pre-Christmas that MI5 were concerned about the provision of information. We've had a lengthy discussion about neither confirm nor deny that policy, whether that policy should stand in every circumstance, whether that policy should not be used to cover significant failings, I think, and that there should be a consequence for people acting outside of the scope of their engagement. We've heard all of that, and right that you outline your position. But the story that was obviously then planted in December and some of the talk around these issues gives the suggestion or impression that there's a concern about whether PSNI and or Operation Kenova under the creation of PSNI back in George Hamilton's day can be trusted with this information. And I think you've fairly responded to fairly responded to those issues and how you've outlined the rationale exactly for your position. So this isn't a challenge to you. The question to you both is, if there were to be a restriction on the sharing of information, the impact that would have on our ability to deal with legacy, on our ability, more generally, our ability to complete the work that you've been tasked with completing, or our ability to even extend beyond. If it was MI5 one day, could it be MOD the next? I'm reassured by the response you've given around the relationships and how there is no truth to it, and that's why I'm sort of reframing the question as to what impact would it have on our societal ability to deal with legacy if there was to be circumstances where a reluctance to share information crept in.
Well, we would come full circle, because information wasn't shared about people, some of whom were agents, some of whom were not, who were going to be abducted, tortured and killed. So they were abducted, tortured and killed. That's what happened. That's the story of the Stakeknife investigation. That's the finding. And for some families, I think, I say in the interim report, these families would have thought they were going mad. They weren't going mad. This was happening, and it should not have happened. And I will underscore again, my experiences was that the security forces and the RUC was the most dangerous police service in the world to be a member of in the 1980s, United Nations report. What they endured, and there's not a week that goes by that there's not a memorial for a member of the security forces. And often those victims are forgotten. I was at an event on Sunday for RUC officers, in fact, Royal Irish Constabulary officers murdered before the creation of the RUC by terrorism. So if we're not going to share information and intelligence, we're going backwards, not forwards. And we see what's happening globally in geopolitics around relationships at the moment. I want to assure you and really underscore, Gavin, the relationships are really strong. I think there is clearly a concern, and I alluded to it at the beginning, that by giving this information out and wrongdoing being found by the security forces, which in my experience was rare, but where it happened we need to call it out so that we can get that public confidence and trust, especially in a society emerging from conflict. But it was rare. We shouldn't use NCND to prevent that from being socialised and examined. And there is an argument given to me regularly that the reason that Stakeknife has not been named is to prevent the accountability of government and the security forces, not to protect agents. Now, I don't believe that's correct, but I can understand why people from certain communities say that. So that's why it's important that I am seen to press what I genuinely believe in, which is where, and it is vanishingly rare, we might need to step away from it. And I gave a couple of examples earlier, where there wasn't any collateral loss of coverage and intelligence, that we do collectively, by agreement, with the Secretary of State agreeing this, step away from it. Not go off, unilaterally and away from the corporate position. And as I say, I've applied NCND more than anyone I know. I've done more public interest in immunity than anyone I know because of my particular background. So I'm a fierce advocate for it. It's just in the legacy space, and this goes actually to the recommendations of the Kenova report, I actually asked, and my suggestion was it's the Cabinet Office that does this, so the government institution looks at NCND in the context of Northern Ireland and looks to review, recodify it and examine it. Have we applied it in a way that actually it's worked against the public interest? Because at the moment, I think we've reached a position that it's in the public interest to name Stakeknife. But not for me to do that as the Chief Counsel of the PSNI. I think that's for the Cabinet Office for government to do, in light of what we've learned. So we're trying to play corporately and fairly and properly. I promise you of that.
Okay, Claire Hannah.
Thank you very much. Chief Constable, you referenced your new recruitment campaign launching today, and I want to acknowledge all you've done to achieve a properly resourced and representative PSNI, and you laid out very clearly there the link between resolving legacy and getting that confidence and buy-in from all communities. And certainly I always take the opportunity to encourage people from across these islands to consider and apply to the PSNI, and hope to do that with you later today. I want to ask about PPS decisions following your report. In spite of your investigative efforts and what I understand is pretty convincing evidence, forensic, ballistics, physical objects, there have been no prosecutions following, none for IRA killers or for FRU or for MI5 accomplices, nothing for murder or conspiracy or perjury or even misconduct in public office. I've been pressing the PPS on this, and they say they will not be externally or independently reviewing their decisions on not to follow with any prosecutions. Do you have any view on that? And I direct that to you, Sir Iain, first of all.
Thank you for the question. I think coming back to my first response to the Chair about frustrations, and you outlined and very, very clearly, the whole series of potential charges that may have come from the investigation. We felt, and we continue to feel, that there were strong evidential cases were presented. I included within the final report a summary of each case. And again, candidly, we had to fight quite hard to have that included, because I think it was important that people did have a clear understanding, the public had a clear understanding of what work had been done. But to balance that, and in recognition of some of the issues that the DPP and his team raised, we did include a number of things round about evidential challenges that you will see within that, and how what we consider to be an evidential threshold in terms of a prosecution, an ability to take that into court and establish that, that there might be a number of different tests that would have to be applied in that regard. Now, I would say, and I think it's important, and I know you were talking probably on the Stakeknife issues there, we have been successful in regard to Operation Kenova. There's a Martin Macaulay is facing murder charges in that regard. I think, again, really, really significant achievement that that only the Kenova team were able to do and progress. And that was facing, under the Legacy Act, the old Legacy Act, that was facing quite a hard stop back in April. And again, in fairness to the DPP and the PPSNI, they moved really quickly. They took a prosecution decision, and thereafter, with a lot of support from judicial authorities and Garda Síochána, the extradition process moved really quickly as well. I had a fear and expectation that this would be dragged out. So that had moved quickly, and obviously we can't go into the specifics and the detail of that, but we would hope that would come into the court domain, and there will be an element of public justice in that regard. But there was frustrations, inevitably. That's that's the life of a police officer or detective often, is that there is a frustration that it's not necessarily taken forward as a prosecution.
Do you think there should be independent counsel review of that decision? Said any reviews will be taken in-house, I suppose, by the same teams that made the initial decision?
Well, I think there is a process, as you know, to appeal no prosecution decisions, etc. And my understanding is that in appropriate circumstances there is an element of independence, mutual support, that they might ask people from the PPS in England and Wales, or the Procurator Fiscal Service in Scotland, and I know from own experience that does occur at times. So within the network of, I suppose, public prosecutors across the United Kingdom and Ireland, I know there are processes where at times they will provide an element of review and inspection, I suppose, but I don't know what's been done in regard to these specific cases, I have to say.
I suppose also on the relationship of informant stories, particularly related to the IRA. Kenova shows that Stakeknife was protected. He was sheltered in West Belfast. He was obviously resettled. We've heard pretty lavish arrangements, football season tickets, wealth management, even the lurid story of the proposed farewell dinner. And during the same time, and indeed in the same constituency of West Belfast, Dennis Donaldson was exposed, and his daughter has characterised in a submission to this committee his experiences have been thrown to the wolves. Based on your investigation, can you indicate why you think those two agents were treated so differently?
I can't comment on Dennis Donaldson. I've seen the I suppose media coverage round about that, but I don't have any specific information round about that. There's no doubt that the agent Stakeknife was given a lot of support. This goes back to, I think, in the interim report, the sense at the time that he was the golden goose, or he was seen as the jewel in the crown, or whatever analogy or language one wishes to use. But we've clearly found out, and I think that was important to try and share publicly as well, about how supported financially and circumstantially the agent Stakeknife was when he was moved, and how that compares to other agents, I think it can be quite stark. But I couldn't comment on why that would be. Do you think
there needs to be any more
investigation
into the treatment of IRA assets and the monies relating to those, and the extent to which maybe political or security interests were taken into account in how they were handled?
Well, I certainly think it's a significant issue of public interest, and what I think Kenova has found out, and how Stakeknife was handled and the circumstances around it. I think inevitably there'd be implications for other agents. I don't have any personal knowledge or information regarding some of these other nominals.
Chief Constable, just in case, if you wanted to comment on any of those issues around PPS decisions or around treatment of agents related to the Republican movement and potential further investigation of those.
One of my recommendations in Kenova was to review and reform the resourcing and operating practices of the Public Prosecution Service of Northern Ireland in connection with Northern Ireland legacy cases. Because our experience, and I set it out in the interim report, of dealing with complex cases, or my experience dealing with complex and international cases in London, terrorist cases, was an incredibly intimate, close working relationship with a dedicated counter-terrorism unit, or if an organised crime case, a dedicated organised crime Crown Prosecution Unit, and direct access to counsel that were advising on the cases. So that you'll be constantly looking at how you can, for instance, get evidence from overseas, Pakistan, Afghanistan, into a court in London. Legacy is incredibly challenging and complex. Because cases are so old, evidentially they are really difficult. There's issues around hearsay, continuity, loss of original documents. You need to have a rhythm between respectful of their independent functions of the investigators, the public prosecutor and counsel, of those people working together to make sure that for the victims they create the best opportunity for that evidence to be determined to reach the threshold for prosecution. Because of resourcing, because of funding, and because of other reasons that I set in the interim report, that did not happen on Operation Kenova. So I suggested an independent review to say, what could we do better? Having an independent review, people come in and say, look, there's no monopoly on good ideas. Legacy seemed to go to the back of the queue. And I was going to explain, because there's contemporary risks that the Public Prosecution Service have to deal with, real risks now. So legacy, we wouldn't get responses on those cases for years. And that is something that I think still hasn't been addressed independently. And I know there's all sorts of challenges to it for the Public Prosecution Service, but I wish that they could put their mind to that. On the issue of, I have to say an interest, I've met Dennis Donaldson's daughter Jane. The jurisdiction of that offence was obviously in the Republic of Ireland. It actually is after the date that's captured by the legacy legislation, the Troubles Bill as is now with this government. It's an investigation for Angana Chicana. I think it highlights the importance of a joined-up approach around legacy between the two governments. It also highlights, I think, and I have examples of this where I've written to the Secretary of State on this, there's another challenge to the current legislation where offending has occurred during the window to 1998 that's captured by the Troubles Bill. Those same perpetrators have continued offending. So, for instance, in the PSNI, we are looking at post the 1998 date Troubles-related cases to 2004. We've got 126 murders that are Troubles-related. Some of those individuals were committing murders and atrocities during the period of time, 68 to 98, that's captured by the legacy legislation. You can't have two separate investigations. So there should be a single truth. And I think in the Angana Chicana case, I think Jane is due to meet the Commissioner, or certainly is asked to, but she deserves a fulsome investigation. And we, because to understand how somebody died, you need to understand how they lived. And we should be compliant with any information that Angana Chicana want about the death of her father.
Should we be considering that a Troubles case and therefore allowing it to have any Article 2 and Article 3 compliant investigation from the new body?
So I don't know enough about the information, this isn't me fudging it, but it feels to me that it would have to be considered at least as to whether this is a Troubles-related case. So I would say yes, a determination would need to be made on that, on the circumstances. But there is something that the Secretary of State and the new legislation I think needs to be alive to, and the Irish government, about making sure that where there's this continuum of offending either by groups or individuals that go beyond the 1998 date, we don't have, because I recently got some legal advice, a ridiculous situation where we have to set up a separate independent investigation that couldn't be the PSNI because we'd be conflicted. It'd have to be something like a Kenova, and we don't have the money for that. You've got the institutions, the resources, the expertise in the what will be the Legacy Commission to deal with those cases that go beyond 98 that have a nexus from before 98. So there needs to be an adjustment to the legislation around that as well.
I'm going to come back on some other issues, but I know...
Thank you, Socialist Wood.
Thank you, Chair. I suppose just to kind of build slightly on what Claire has actually brought out there is that it's so difficult to have these conversations. I mean, there's not a single family in anywhere across these islands, not just in Northern Ireland, because we have to remember that the Troubles spanned not just these islands within the UK and Ireland, but continental mainland Europe as well. And, you know, it's an absolutely huge undertaking. And what I've taken from this session so far today is that actually, and we had a brief discussion about amendments to the Troubles Bill just prior, it really does feel that there is an awful lot still to go in terms of how we actually still learn from Kenova and actually the wider societal conversations. And Kenova has garnered a reputation, and probably one I share as well, for being very good with families, and I think that's a positive thing. Obviously there was some criticism maybe is a strong word, but criticism, to use that for want of a better word, about the results, findings, final report, whatever you want to call it. Were there any families that didn't engage with yourselves throughout the course of that, and Terma as well, I suppose? Were there any families that walked away, weren't happy, and just didn't want to get involved?
So I have to say, I can't think of any. What I will say, in advance of Christmas, I emailed all of the families, which I do every year, and try to contact them on anniversaries and stuff, and often I fail, but I try. The responses I got from those families, and that's families from Kenova, that's families from Denton, it's families from Terma, it's families from police officers, wider police officers, because there's lots of overlaps here, military families, were, for all the criticism that you get, and you get a lot of criticism, for the team it makes it all worthwhile, because we've changed their lives with regards to the engagement, listening to them, acknowledging what they've been through, and where we can, telling them what we found, even where, and it's been discussed in this session, that wasn't what they expected to hear and didn't want to hear. But it's how you deliver that. Mm-hmm. And I can't think of a single family, and we met such challenging families, and I think we had every possible sort of type of challenge that you could have in a Troubles-related case. I can't think of one family that's gone rogue and in the media and said this is a disgrace and a waste of money or whatever. Not at all. Commentators have done that, and you'll get that. Some people don't believe we should have any legislation for the Troubles. Draw a line under it. The Malone Group. Don't do anything now. Stop it. And you have to listen to all those views, in my opinion. But I can't think of one family. I'll probably get lots of messages now to suggest there are, but I can't think of any.
No, likewise, and again, before the final report was published, I ensure there's a message goes to all families. They were given prior access to it, as long as the committee and others, just in terms of having an ability to read it and see it before it started to be discussed publicly. And of course, even within families, we've worked at times. We might have to have 2 or 3 different levels of engagement because families are complex, yeah. And particularly you might have a group of siblings, and one sibling does not want to pursue a matter of progress that maybe the majority of the siblings wish to do, and we need to recognise that. And I do think that's one thing that is, I think, one of the lessons from Kenova, and something I think that needs to be taken forward. And I do think there's an attempt to do that. And I know it was touched upon even, I think, in the committee's report, that not one size doesn't fit all for victims and families. Some families and individuals and victims would really seek a full investigation and a criminal justice outcome. Other families don't. Other families want to get some information, and everything across the spectrum between that. So I think that's something that's very important in anything that's built as well, that it has to be, you almost have to have a process, and whether that's through the Information and Reconciliation entity that different from the Legacy Commission, and how the two work together, that you're given options almost to victims and families as to how they wish matters to be progressed. And then you get other victims and families who say, look, we wish you well, but actually don't just give us an update when you've got one, and we want just to live our lives. But there was, some of the feedback and the testimony that we've heard from families are it's because of the sensitivity and the confidentiality of it. It's difficult to go into detail, but really, really deeply moving. Mm-hmm. There was 2 sisters who had moved out to North America, and their father had been a victim of the Glenanne series, and again had over the years had built lives and were living separately. And our officers went to tell them, and it was different from what, back to one of Gavin's earlier, it was different from what they had thought we were going to tell them. But actually, a week later, they came back and said, look, we've now got peace, and that's something that we've waited decades for. And our children, this intergenerational, although these they've now got families in North America who never set foot in Northern Ireland or the UK or Ireland. They've had that impact, coming back to your earlier point about how wide the impact can be. So the fact that we'd carried out our inquiry, the fact that we'd then shared with the outcome wasn't what they thought it was, but they had a resolution that they never had for decades, and it was genuinely a very, very moving thing to read.
Just to come back briefly, finally, on something that was said earlier in terms of yourself, Chief Constable, about police and families. I'm very proud of the service of the REC and the people that were close to me that served and still do the job now. And I really think it was important that you said what you said today, because there has been very much a feeling, certainly within the police and family, that there has been an attempt to wholesale rewrite history and completely discredit all service. And they will be the first people themselves to say, listen, where there was wrongdoing, absolutely, let a light be shone upon it. And I think what you have in Terma was an example of where so many families wanted to have that similar conclusion themselves. And would you agree with me that actually it really is important that we don't leave behind police and families in this, where they have just taken as read that they are now just discarded, and it's been 30 or 40 odd years. They've consigned themselves to the fact that they feel that they'll never get any conclusion or answers or closure as to what happened. Do you think it's important that we remember those families too whenever we're having these discussions?
So 100%, that's why I mentioned them at the beginning of this session, and I go to services all the time. I think you know that. I've actually brought families. We have an incredible memorial garden at headquarters at the Police Service in Northern Ireland. A number of families, police families, didn't know we've got that memorial garden. We have a great organisation, the Royal Constabulary George Cross Society, who look after the garden so people can come and remember their loved ones. And we mustn't forget either, by the way, the number of people who suffered life-changing injuries that they have to live with every day, and psychological injuries. And I've not met anybody in the police service who served during the Troubles who's not been significantly impacted by it. It changed people, without a doubt. And I've said within the PSNI, we will absolutely memorialise, remember, respect the sacrifices that each of them made. And it's such a complex thing. And when I came into the PSNI, I think, and I've said this to the organisation, people would often not speak about the RUC because they felt they weren't allowed to. And that's changed. And when I say that we got things wrong in the security services during the Troubles, surely we were going to. It was impossible. Nobody could have dealt with this. And if you made one decision to go this way, there'd be a life lost over here. If you went over here, there'd be a life lost over there. My point about Kenova is, where institutionally we got things wrong, and I say again that we didn't give them the tools to do the job, we didn't give them the legal framework, we didn't give them the guidance, the training, and they were asking government for it.
We're asking.
Because of the sacrifice, because by and large they did such an incredible job, the like of which none of us could understand. That doesn't mean we don't say when we got it wrong, we got it wrong. That's about public trust and confidence. And I think we've got the decision not to make the determination that Stakeknife will be named, not on occasions to reveal information, not breach NCND, but reveal information where we know there's been wrongdoing so it can be properly examined and learnt from, and families can then understand better what happened, because that's what the Stakeknife investigation is. I think that's how that still holds us back, and we need to change that.
Anna.
Thank you very much. The interim report proposed reviewing the classification of previous reports. PSNI have refused the release of the 1973 Morton report into special branch activity, and your final report, I think, indicates no progress on that. Would release of that document, or even an indication of its principal findings, help us to understand better what those in power knew and when about the handling and mishandling of agents?
If I can answer that one first, if that's all right. So when I did the interim report and set out those 10 recommendations, my hope and expectation was I'd engage with government and there'd be a government apology, because that's in there around what's happened, some of which we've aired today. And there will be a government-led response to the recommendations. So the recodifying within the Northern Ireland context of neither confirm nor deny. The date for victims to be remembered on the 21st of June. With regards to those reports, they have various owners. The PSNI own a number because they were commissioned by the Chief Constable. I have instigated a piece of work to do a security review of those documents. Because this hasn't happened from a government perspective. And my intention is, so this work's underway, is to then go to partners in the security agencies, the Secretary of State, the Northern Ireland Office, and our partners, to say these documents were commissioned by the PSNI, RUC. I think that having done the security checking, these documents can now be put in the public domain. There's no risk to anybody. We don't breach NCND. We don't impact negatively on any security issues. No one's put at risk. No methodology is released. How do you feel about that? You do your own exercise. So I'm going to do that process because it hasn't happened after the 8th of March 2024 release of the interim report. And I know that Iain has been pursuing through the Cabinet Office a mechanism for those recommendations to be delivered upon. And that includes the Morton report. That's on the list of reports, if that helps.
Yeah. Again, that recommendation has, I think I'd say in the update on the final report, is that it hasn't made the progress that we would have wished. Because of, John outlined, the multiple interest, multiple input into a number of reports, but ultimately there will be one sort of designated owner. But to get that coordination, our view, certainly in discussions, was that John touched upon it in regard to another issue, that the natural place that would sit would be Cabinet Office to provide that oversight, that link into the security services and back into the other departments of government as well as others. Now, that has not made the progress. The update that we received from the Secretary of State in regard to the recommendation about a public apology, again, we're told, well, that's on hold because of civil litigation and a number of issues. So I do think that we've published our final report and we've had the updates, but I think there's far more that could and should be done. And clearly, we are expecting an update on the recommendation regarding identification of Stakeknife, and within that, the recommendation, one of the other recommendations of the 10, was regarding the need to review the application of NCND within the context of Northern Ireland. But the declassification of the reports, I think, something else that's not been progressed. Perhaps because there's been a legislative change and there's been other issues that have been dominating the NIO's agenda. But those recommendations stand, and to my eyes, they still haven't been fully addressed. Again, John mentioned the state apology as well.
Thank you. Okay, thanks. Robin Swan.
Here.
Welcome, Robin Swan.
Thank you very much. Iain, just following on to that in regards to those 10 recommendations that were in the interim report, where are they sitting at the minute and where do you see the urgency in moving them forward? Because the concern that I would have, Kenova was commissioned by the Chief Constable of the PSNI, so at times there's a concern with me that maybe Cabinet Office government, because of the commissioning source, doesn't take the recommendations with the clout or the seriousness that they actually do come with in regards to the work that has been done. So could you just give me a feel of in regards to those 10 recommendations, where they actually sit in regards of urgency and also delivery?
Okay, thanks for the question, because it is a concern of mine that ultimately, with the Troubles Bill ongoing, the Legacy Commission, the fact that Kenova has to come to an end, that there is no there is no ongoing monitoring group that I can say, here's 10 recommendations, you've now got them. Perhaps other than this committee. I mean, that's one thing. I know the committee, the activism and the knowledge around here will keep that level of interest, pressure, whatever one wants to call it, on government and other agencies. But it'll be. It's not now. Although the final report, I've still got a number of issues to resolve. Not least of all, to get that update from the Secretary of State on the specific issue that he wished to defer until the Thompson judgment on the naming of Stakeknife. But the other recommendations, you'll see that a number of them have been, you could say, have been discharged. There is a structure, a framework. We've now got the Troubles Bill is there, with RIPA and other provisions that exist there, and then there's a number of other issues that have simply been unaddressed. And I think, other than me asking again through the NIO for updates on that, I would ask again. I don't have anything in my own mind, Robin, other than probably the authority of this committee to keep those recommendations under review.
John, can I ask then, as current Chief Constable, then, where's your concern in regards for piece of work that has been done, recommendations sitting there, but really, I think as Serena said, no ownership or no accountability with them once the final piece of work's done?
To be honest, this was always going to be a challenge. So when I did that research, speaking to people who'd done previous legacy work, and John Stevens said, you need to get an agreement, you get a report out, John. Because my biggest challenge, and you'll know Stevens' reports have still not been fully published, they were written with the intention of being published by John, who we both speak to very regularly because of his experience in this area. All I can say is, I will, whilst I'm Chief Constable, at the end of Kenova, each of those recommendations are not going to disappear from my mindset. I will be lobbying to do what I think is right, properly, with the auspices of corporate agreement, and that I'm not going to go off rogue. But I think, and I've read all of these reports, all of them, there are so many. I list a number of reports in the interim Kenova report. All of those I've read. Some of them are very voluminous. And by and large, the conclusions, the summaries, the executive summaries are don't touch on any specifics that I think attract national security concerns. But I would want colleagues in other agencies to agree that. And I think it goes to the point, and Claire acknowledged it, of again trying to change the atmosphere towards the establishment with all communities, that would be quite an iconic moment to release a number of reports. I think a lot of people would be quite disappointed because although they clearly say things were we got things wrong, they're also quite positive about stuff that was done. They're not as dramatic as people think. They're actually very sensible reports. And some of them, I don't understand why we've kept them locked behind this wall of secrecy. So for me, at least, I think I can advance that one. And the government apology one, I think that one, if the naming of Stakeknife was undertaken, I would see that as connected quite strongly to saying, look, institutionally, because members of security forces were asking for help, they're asking for a legal framework, I would see them as connected because the government's been silent on that, the previous government and this government. And I know they say it's because there's ongoing legal activity, and I said it at the launch of the Kenova report. I've never seen such a litigious society as Northern Ireland. There is legal activity everywhere. And I'm sure, I can't speak from actual knowledge, but I'm sure there was legal activity with regards to Bloody Sunday and the Savile inquiry when the government apology was made. I'm sure there was lots of legal activity. So it would just be good to do the right thing. And I promise you that I'll continue to lobby for it, but in a sensible and responsible way.
Okay, Mike Kane.
Thanks, Chair. There's a lot to ponder, for sure. I'm going to stick to my question around legislative change, if that's okay. So this individual threatened to string people up, threatened to skin them alive, forced confessions from people, then did it anyway, and then played those confessions to the victims' families. And he ended up with a house in my neck of the woods and a season ticket at my football club, living the life of what we would say in Irish, Riley, effectively. And, you know, it's very difficult to comprehend. I probably rubbed shoulders with him at either Main Road or the Etihad Stadium. But that's quite painful this week for Mancunians, because you alluded to it, Chief, in the fact that the government yesterday pulled legislation on the Hillsborough law for the duty of candour, because MI5 do not want to have the duty of candour, which would be truthful, transparent and proactive. So they're coming back to it, rightly. I'm not criticising government or MI5 in this. But when the arena attack happened in 2017, the failures that happened were rightly looked at by the Kerslake report. So the police, the ambulance services and the fire brigade all had full investigations. But those families, as in item 5 of the Kenova report, feel that MI5 gave false, misleading information was passed to families. That's how they feel. And we can't get away from that. You've alluded to the way you've worked with families. We also know that MI5 gave American intelligence services the name of Salman Abedi before GMP wanted to release it. The problem for politicians is we had a full investigation of your services, but we can't get to the bottom of the answers for these families or for the intelligence failures, if there were intelligence failures. It's not, I'm saying that there were, but we just don't know. There is no mechanism to do it. So I'm just wondering what your counsel would be in terms of the duty of candour when it comes to intelligence services. What would you counsel the government to do?
Well, firstly, only because you mentioned, if you like, stepping aside from NCND, in the interim report, we give a number of examples of where that has happened, where, because it suited the government to do it, we have done it. And I talk about the public interest test with particularly this case, what they're going to do. What I would say, the duty of candour is something that came from Hillsborough. I remember Bishop Jones coming to see us all at National Police Chiefs Council, and I was surprised by the hesitancy there was around it, because it sounds like a no-brainer around public institutions being honest around what's occurred when there's been a specific critical incident. And it was the lawyers, again, talking about culpability, responsibility, liability. Now, I have met all of these families, and a lot of them have got legal cases against the PSNI or the MOD or the NIO. And the lawyers say you can't go and meet them. But you can meet them, and you can talk to them, and you can give them information without affecting those legal cases. So I was frustrated by the initial resistance to policing, to the duty of candour. Policing is now in the right place around that, and I can tell you the PSNI, we're reviewing, in fact we're producing now a new code of ethics, and we're wholly supportive of the duty of candour. What I do think is that the security services, and I spoke about this again earlier, they have a completely different function and role to the police. And whatever their arguments are around stepping aside from or having some protections from the duty of candour, I always believe we should listen to. But I looked at the Manchester inquiry, I followed it very closely, and some friends of mine were involved in it from a legal perspective. And MI5 said that they welcomed scrutiny. Through that particular process, that was a council comment from MI5. And I think the Director General does welcome scrutiny. But institutionally and culturally, it's quite difficult for intelligence agencies to display that in a more open public way. But we need, I think, to achieve that in ways that we currently do with the intelligence agencies. So I think they need to change. And there's other cases recently as well. But they are very different to the police and our accountability measures, and they shouldn't be considered in the same way. So it's a difficult space, but I do think You know, our democracy, a well-functioning democracy, is based on lots of different things, but how we protect our citizens, how we respond to legitimate accusations of wrongdoing by government and security forces. And we don't want to be judged in the same way as we criticise other states. We want to be more open and transparent and have independent processes. And I do think there is a territory to move the dials with regards to how that has happened with the intelligence agencies. And particularly, that needs to change in Northern Ireland. And that is what I'm very open about, I'm trying to do, but try to do sensibly, in a measured way, and with the agreement by lobbying my partners in other agencies and the Secretary of State.
David Smith.
Thank you, Chair. Thank you, Chief Constable and Sir Iain. You've been very open and insightful in your comments. This is the last question, I think, unless anyone wants to follow up. And you've answered actually some of the questions I would have otherwise asked, but I'm interested in what you were both saying about, you know, how does Kenova continue to live on? You know, what's its future? And there may be various ways that can happen, but one of the obvious things is how it impacts the Northern Ireland Troubles Bill. And so I kind of just really want to give you a kind of carte blanche to say, if you could change anything in the Northern Ireland Troubles Bill, such so that the lessons learned from Kenova could really embed themselves in the way that this country deals with the legacy of the past in Northern Ireland, what would it be? And that's to you both.
One point I would highlight, and you know, we do say we support the bill in general and the framework. It is around back to information sharing and who makes that determination of what is provided. So the issue on sensitive material, you know, that assessment is, as I read the bill at the moment, that the obligation for that assessment vests in the organisation who holds information and has been asked of it. And I think that the experience of Kenova, and I touched upon Chapter 8, which I said is probably one of the drier chapters, but in the final report, around about putting the onus on the investigative body, i.e. the Legacy Commission. Jon talked about handing them the keys. So they go in and take the material and carry out an assessment. And then if there is an issue on national security, there's a process that comes to that. I know this committee recognises that, you know, ultimately the Secretary of State is probably the best office to carry out that ultimate moderation role that has to be taken. But it would be about information sharing and who takes the decision about who gets what. You know, Kenova showed that it was only when Kenova went in to the PSNI itself, to the MOD, and got close to MI5, that they were able to make sure that all the material was obtained. Whereas at the moment, there's a duty, and it's a burden as well. It's a burden on organisations such as the PSNI having to carry out that assessment regarding sensitivity. So that would be the one thing I would focus on.
Thank you, Sir Iain. Chief Constable.
So I think I need to mention the 10 recommendations from Kenova. I think as a platform, I genuinely think this Secretary of State is incredibly well intentioned, is working really hard to move things forward. And I very much welcomed the wording of the Troubles Bill to succeed the Legacy Bill in what he's trying to do. So more transparency, more independent oversight. And that, I have to say, I'm sure Iain would agree with me, the independent groups that helped Kenova, the support they gave us, the expertise, the credibility and the scrutiny, really have significantly helped us get to this position with these reports. And that's the oversight group, very much the independent steering group, which is subject of expert sort of senior police officers who've done all sorts of difficult stuff all over the world, but very much the victim focus group. And the victim focus group did an independent report about Kenova, that independent scrutiny that we talk about. So I think for the for the Secretary of State to look at as a platform, as a beginning for this new journey with legacy. Look at those recommendations and see if, because they will have long-term positive impacts, I think, on the bill. Iain's alluded to it, this Schedule 4, I really worry, both as somebody who's led a legacy investigation, but as the Chief Constable, about the collateral implications of that on families thinking that the PSNI are in some way, which we would not be, but as some way, because there's a legal burden on us to do this, categorising information around sensitivity and providing a determination around its prejudice. I don't think we should do that. I don't see any, from an investigative perspective, any grounds for it. I don't see any grounds for it from a national security perspective. And certainly with regards to trust and confidence of communities, some of whom do not trust the PSNI because of some of the cases we've talked about today, it will add to their concern around this process going forward. And he's well-intentioned, so I hope he sees that there is a need to reset that. It will also cost the PSNI significant resource. And when the Patent Commission occurred, which created the PSNI almost 25 years ago, the structures, the accountability, the makeup of the organisation with regards to recruitment, the oversight with regards to the policing board, all put in place. Nothing was put in place around legacy. I don't think Lord Patten would have had any expectation that 25 years later we'd be having these conversations. And it was probably too difficult to deal with at the time. But we are desperately short on resources. And by being associated with doing this work, it's a double whammy against the organisation. It's costing us £24 million a year to just manage at the moment. This will increase the volume of our work significantly. And we have no money in the executive to provide the PSNI to do that. So there will be delays. There will be mistakes. And it will reinforce the narrative that the police are not to be trusted when actually we're doing our best. So that particular issue has quite significant consequences, and if we could just change that and provide funding for what we do need to do, because that's never been considered. And I get sent by the Secretary of State to the Executive and by the Executive to the Secretary of State, because they'll say this is Westminster related, and Westminster will say we give a significant grant to the Executive, it's for them to pay for this. So I'm cut between the two. But it's so serious, it's so important for the PSNI and Society Northern Ireland, we need to resolve that as well around the funding for the PSNI, around legacy issues. The outstanding legacy issues we've got, I talked about 197 cases. 71 of those were during the Troubles period, but they're not Troubles related that we're examining, reviewing, investigating. The others are 98 to 2004, as I talked about. That is a significant commitment that we're not funded for. We think that's £60 million, okay? But because of civil litigation, because of compensation, we think that that could go towards £1 billion over the next 10 years. It's £1 billion we haven't got. So unless we come up with some framework to deal with that, the PSNI will still have this anchor holding us back from moving forward. So let's focus on the Legacy Commission and what we can do to get the structures right. But there's wider implications, and colleagues in the PPS would say, think about us. The Department of Justice would say, think about us more widely. So it's a wider conversation than just getting the legal framework right for the Commission as well.
Thank you. Thank you both.
I just need to bring in Saoirse Eastwood and then we'll wrap it up.
Thank you so much, Chair. I'm really glad that you raised that, Chief Constable, because whenever I spoke to this on the floor just before Christmas, one of my major concerns was that, say we do get something that parties broadly are prepared to accept in terms of the Troubles Bill, My biggest fear would then be that actually we have hamstrung the PSNI from the off because we know rightly that there isn't the funds there to do it, and you're in the dock yet again. And as you're quite right to say, there's the double whammy. There's one, the community reputation piece around legacy and how that is damaging relations still to this day, and second of all, the fact that we have then gone out publicly as the House and said we've agreed this, but actually there's no money for you to do it, and yet again you're in a situation where you're struggling to make discovery requests, you're struggling to make council requests and whatever else. I do think that there is a very clear argument to say to Westminster, actually you do need to adequately resource this. I've tabled a number of amendments, and it's difficult to try and get things drawn in terms of resource. But would you agree that there is very much a case to be made to say that Westminster do need to ensure that if we're going to legislate on this, that we make sure it's adequately resourced?
These cases were during direct rule. There is an obvious, sensible argument that this, in the same way that the government are funding the ICRIR and the Legacy Commission, which has already spent, I think, from a response from the Secretary of State to this committee, was 50 million in September, of 250 million. It's really difficult, the resourcing of this and the construction of this. But don't leave us out on our own, because it'll fail. It'll be a single point of failure, not because of the willingness. I think you will see that my organisation is determined to get this right, but we can't if we haven't got the resources to do it. Or you put additional legal burdens on us, which Iain described around Schedule 4.
Thank you. Can I thank you for your work in Kenova and your time today, because it's been quite a big session, so I'll call it to an end.